Hello, I'm Silvia Chaver from ICC, and joining me today is Georges Affaki, Chairman of the Legal Committee of the ICC Banking Commission and Council Member of the ICC Institute of World Business Law, to discuss the forthcoming ICC Institute Spring Conference taking place on the 23rd of May. Hi Georges, could you give me a brief overview on this Institute conference on jurisdictional choices in times of trouble?
Sure. Hello, Sylvia. Delighted to be here. The starting point is actually a paradox. I mean, here you have what is by all means one of the most important clauses in an international contract, whether construction, procurement, or finance, which is also the shortest and usually hidden at the end of a voluminous contract. This is the clause that will determine the judge or the arbitrator, who will determine the applicability of the contract, which will lead to either considering that the clauses will be enforceable or null and void. And this jurisdiction clause, Sylvia, is meeting some of its most severe challenges ever. Some courts in the world are canceling the clause altogether because they perceive some options to be granted unilaterally to one party but not to the other, creating the myth of asymmetrical jurisdiction clauses. Other courts are approving such a distributive option. Other courts of law or tribunals are also criticizing some aspects of determining the arbitrators who will sit on the tribunal and how to appoint them. And all of that is creating a great deal of uncertainty in the market. Certainty means cost. It means also that at a time when our global economy is as fragile as one can get, we are not helping the contract parties and their counsel to determine ex ante the legal certainty necessary for them to draft a jurisdiction means that will allow them to resolve their disputes. And that's when my co-chair, Horacio Grigera-Naon, and myself offered to the Council of the Institute that we would dedicate this year's spring conference to addressing comprehensively, holistically, all the challenges that jurisdiction clauses are causing today. And I'd like to pay a tribute to the vision of the chairman of the Institute, Yves Durance, the vice chairs and the members of the Council of the Institute, who were immediately supportive of the idea. And one thing led to the other, and we have now a wonderful program, and I'm very glad that we're looking forward to next week's event, the seminar.
And Georges, I hear this comes in context with the Brussels regulations.
Absolutely. It's actually a dramatic change of the landscape, but not only in Europe, also in the world. You're absolutely right in referring to the coming into effect next year in Europe of the new Brussels regulation on the recognition and enforcement of judgments, which will determine brand new series of jurisdictional rules within Europe, but also the case of handling multiple procedures, which is what we call dispendence. But this comes at a time when the European Commission has also made a proposal to the European Parliament to ratify the Hague Convention on the Choice of Court Agreements. And this convention, contrary to the regulation, applies globally. So we will end up with two jurisdictional standards: the Brussels regulation, which will apply within Europe, the Hague Convention, which will apply extra-Europe. The solutions are not the same, and this could cause challenges. And I'm delighted that we were able to unite some of the best specialists in the world, coming from America, coming from Europe, and from the Middle East and the Gulf, to address in a global, interactive way the various challenges that the New Deal offers.
And mentioning this interactive component, how is it specific to the ICC Institute conference?
Well, this is something that we're very determined to have. We will have very stringent chairmanship, and because I'll be one of the co-chair, I can promise that times will be observed. Each specialist was requested to keep their remarks to less than 10 minutes, which means that we will have at least twice that time for interactive exchange with the room. So you will have the panel of specialists addressing the issue not only from their own local law standpoint, but also holistically with a novel approach that would transcend the local challenges only. And then the participants are expected to react to that approvingly, challengingly, and I'm hoping that this will get us to the kind of debate that we need in order for us to have questions matched with answers. There are many, many questions, And my job as co-chair will be to ensure that everybody exits the event with at least as many answers.
That's great. And now that you mentioned the participants, who exactly does this conference appeal to?
Well, it has to be as broad a spectrum as possible of legal practitioners and academics. I mean, basically an event that addresses the challenges in jurisdiction clauses in international contracts should draw a strong appetite from arbitrators, from judges, from lawyers, whether they're sitting in-house in companies and banks or outside counsel. It's essentially anyone in whose practice the issue of the enforceability of a jurisdictional choice, whether arbitration or courts, might arise. And remember, a key feature of this event is that we will be dealing in parallel with arbitration choices and court choices. And this promises a unique and unprecedented debate.
And as the co-chair of the ICC Institute Spring Conference, what would you personally highlight from this event?
I guess the quality of the debate will be really unique. I mean, the top specialists coming from the world of academia and world of practice will be meeting for one day here in Paris at the ICC headquarters for the event to discuss those challenges and make sure that we bank on the wealth of expertise that will be in the room to find what is really the cautious approach and the answers to those challenges. But beyond that, this will also be a unique networking opportunity. Participants will be able to address some of the top experts, some of the most sought after arbitrators and judges to discuss with them all the challenges that international contracts in the challenging world that we live today are really raising. So I look forward to that debate, Silvia.
Certainly, and we look forward to seeing all of you there as well. Let me remind you that this ICC Institute conference on jurisdictional choices in times of trouble will take place on the 23rd of May, and you can find more information on www.iccevents.org.